Buckle up, because what you're about to witness is one of the most jaw-dropping courtroom turnarounds in recent memory. Today, Judge Boyd faces off against a defendant who hasn't just violated probation, she's disappeared for nearly an entire year. But that's not even the twist. She walks in with a heartbreaking health diagnosis, an emotional plea, and a story of missed calls, lost paperwork, and supposedly congestive heart failure. Is she truly a victim of the system, or a skilled manipulator buying time with sympathy? And just wait until you hear the judge's verdict, it might surprise you. Watch closely. From courtroom confusion to medical excuses to a shocking sentence, this case has layers. So, who's telling the truth here? Who dropped the ball? Probation, the defendant, or everyone? Let's find out.
Someone in the audience?
Who it is? It's Christina Hernandez.
Oh, her name is Christina Hernandez? All right, who's the person here for Christina Hernandez, the family member? Christina Hernandez, who's your family member? Who is your family member? All right, you need to step outside the courtroom.
Did you catch that? Judge Boyd shuts down the courtroom audience right out the gate. That wasn't just a scolding, it was a power move. In many courtrooms, signaling or speaking from the audience is a serious violation, especially when security's on alert. It may seem harsh, but in high-stakes cases like this, the judge needs total control. One wrong gesture could disrupt proceedings, or even hint at jury tampering in other cases. This sets the tone. Boyd runs a tight ship, and today, he's not in the mood for games.
Or talk to anyone in the audience, because the deputies are here for everyone's security, and they don't know what you're signaling people for. This is not a time for visitation. If you want to do visitation, you need to do it at the Bexar County Jail. No.
Yeah, I remember that part.
And I think it's slipped out a little bit. I saw one picture of him that online. I was like,
He looks completely different.
Really?
Yeah.
really.
All right, court is calling 2021 CR 2960, State versus Kara Michelle Clark. Can I have parties announced for the record?
Jason Gary.
Brandon Lopez for Ms. Clark.
And are you Ms. Clark? All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and State's motion to supplement pending motion to enter adjudication of guilt and revoke probation with your attorney? Did you understand it? Are you the same Kara Michelle Clark who was placed on deferred adjudication in 2021 CR 2960 for the offense of theft under $2,500 enhanced on March 2nd, 2023 for a term of 4 years? Is that you?
Yes.
All right, state.
Provided Kara Michelle Clark, they did fail to report to the supervision officer as directed for the months of January 2024, February 2024, March 2024, April 2024, May 2024, June 2024, July 2024, August 2024, September 2024, October 2024, November 2024, and December 2024, violation of Condition number 4.
She just admitted to violating probation, and not just a little. We're talking 11 months of no contact with her supervision officer. In the legal world, that's not a small slip-up. That's called absconding, and courts take it very seriously. By pleading true, she's handing Judge Boyd the legal green light to revoke her probation and sentence her to time behind bars, the only thing standing between her and a jail cell now. A plea for leniency and a compelling explanation. For her disappearance.
All right. How do you plead to that? True or not true?
It is true.
State? Any objections?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to $10,000 fine?
Understand, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4?
It is the truth, Your Honor.
But do you still wish to plead true to violation of condition number 4? Court will find violation of condition number 4 true. Is there a proposed agreement? State, what are you requesting?
States.
Defense?
Your Honor, we're asking to go with the recommendation of probation, which was to continue weekly UAs on the IVR line for 120 days with zero tolerance, amend TAP recommendations, register within 30 days for the theft level 1 program, followed by the theft level 2 at CATS, and intensive outpatient treatment.
All right. Has she done anything on probation?
Your Honor, she has not. Shortly following her plea, she was diagnosed with congenital heart failure. She reports to me that she's been doing odd jobs living at the same location at which she was at when she got on probation, essentially dealing with those ramifications. She also reports to me that her diagnosis is for 6 months if she does not get a new heart.
This is where it gets complicated. The defense drops a bombshell: congestive heart failure, limited time to live, and a desperate hope to remain free. But there's a glaring problem here: no documentation. In court, medical claims need proof: paperwork, diagnoses, doctor statements. Without it, this could be seen as an emotional play rather than a verified fact. Judge Boyd knows this, and you can already sense his skepticism simmering.
So she's asking for the opportunity to continue on probation on the outside with her limited time available.
All right. So do you have any medical proof of any of this?
And Your Honor, I asked her about that. Obviously, I do not have it at this time. If it was important, obviously it is important to the court. I could attempt to get that. I don't know how easy that would be with her being on the inside, but that's what we could do.
All right. So all you had to do was call probation.
Yes, ma'am, I did. But I didn't call them until it was 2023.
Oh, you want to raise your right hand?
Yes, ma'am.
Do you
To me,
solemnly swear or affirm the testimony you give will be the truth, that nothing but the truth shall help you, God?
I do, Your Honor.
All right. You can lower your hand.
Yes, ma'am.
What did you want to say?
I contacted Tamia Dixon, my then probation officer, and it was December of 2023. And I went back to the hospital in November. I was diagnosed in August, and I went back in November, and they told me that I was deteriorating. I had lost 5% of my ejection fraction in those couple of months, and that's when they
So how long were you in the hospital?
for a week at a time, both times.
All right. Did you call probation and let them know you're in the hospital?
Not until the second time I called her when I got out.
All right. And when were you released from the hospital?
A week after, it was the day after Thanksgiving that I went in. So it was about 6 days later. I was really.
Judge Boyd just gave her the benefit of the doubt for January, despite no solid medical proof. That tells us something. He's trying to be fair. But February through December, that's another story. It's hard to argue that a full year of silence was caused only by health issues. And this isn't just about missing a few check-ins. It's about complete disengagement with the system. The court is losing patience, and it's about to
I was
show.
released.
All right. So January 2024, and I will even give you January 2024 because I'm like, you're in the hospital for November, then December, you got Christmas. January, usually people are still recovering from Christmas, and it's a holiday season, the month of January. But they say that you didn't report for February.
Yes,
What was
ma'am.
happening in February 2024?
I had called back in January like Miss Dixon had asked me to, and she was no longer my probation officer. I had been reassigned. And I called my new probation officer multiple times, and she never contacted me. So I tried to contact Miss Jennifer. I don't remember her last name, the lady in charge of all of the adult probation officers.
All right.
in
So
their
you're
county.
saying that you were not able to get in touch with anyone
Yes, that is
February, March, April, May, June, July, August, September, October, November, and December. So then basically the entire month of December 2024, the entire year of 2024, you were not able to contact anyone.
I gave up after about 3 months.
Okay.
And Your Honor, I apologize. I know that I should have.
And there it is, the quiet confession. She admits she gave up after 3 months of trying to reach probation. That moment right there might have sealed her fate. In Judge Boyd's eyes, giving up is not an excuse, especially when the court is literally an option. He even reminds her, you could have come back to court, but fear of jail overrode every responsible decision she could have made. The emotional honesty is powerful, yes, but it won't erase a year of inaction.
Done something more, but I was afraid of going to jail.
All right. So here's the thing. I tell everybody, if there's an issue and you feel as though probation is not addressing it, you can always come back to the court. Did you come back to the court?
No, Your Honor, I was
Right.
afraid of going to jail.
All right. So the court is going to grant the motion, find you guilty. What time are you asking for, state?
The state had recommended 108 days state jail facility.
Your Honor, that's the minimum, so we would be asking for the minimum if we're going to revoke.
All right. So my question is, why should I give her the minimum? She hasn't done anything.
Your Honor, I think, well, I don't have any paperwork regarding her diagnosis, but it seems to be truthful. I do think that that she's dealing with these health issues. And
Judge Boyd hits the nail on the head. Why should I give her the minimum? She hasn't done anything. This isn't cruelty. It's accountability. Probation is a second chance, and she didn't complete a single requirement. Even the defense is scrambling, admitting they believe her story, but have no hard evidence. The judge has to weigh sympathy against public safety, precedent, and fairness. And without documentation, sympathy just isn't enough.
and we'd ask for the minimum for those reasons.
All right. I'm going to sentence her to 1 year in the state jail facility. Counsel, if you're able to get documentation to the court that what she's saying is the truth, I will reconsider the sentence.
Okay, thank you, Your Honor.
All right. So this 1 year in the state jail facility give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, I did.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right. So yes, counsel, bring me the information and I'll reconsider.
Thank you, Judge.
All right, you're welcome.
And just like that, Judge Boyd lowers the gavel. 1 year in a state jail facility with a lifeline. If the defense provides documentation of her diagnosis, the court may reconsider. This isn't just a sentence. It's a lesson in consequences, accountability, and the razor-thin line between mercy and manipulation. So, what do you think? Was the judge too harsh, or did she have it coming? Could more transparency from probation have helped? Drop your thoughts in the comments, and if you found this breakdown as compelling as we did, hit that like button, share with your fellow courtroom watchers, and subscribe for more intense legal showdowns. We've got more Judge Boyd drama coming your way. Don't miss it.